getting close.
How much longer do you think we got?
Well, we'll be out of here by 6, hopefully.
Okay.
Okay, so anything you say can and will be used against you in a court of law. If they stop you, ask them for an oath of office, their bond, and their commission. You know, I was listening to this talk radio program, and this guy from Montana was saying that he has a friend that's a county sheriff. Of course, this is a friend, and he asked him, you know, what would happen if I asked you for that? And the county sheriff says, well, I'd tell you to have a nice day, and you know, you're free to go, basically. Absolutely. But so always be very polite. I tell them I don't want you to take this personally. I appreciate the work you do. I have no idea how much you get paid. We need people to hunt down murderers and thieves, and in my opinion, it's not enough. You got to kind of, you know, tell them you appreciate what they do. As one of the people, I always tell them, as one of the people. Anyways, I have no first-hand knowledge of the day I was given birth, and anything about a date of birth is hearsay and inadmissible as evidence in a court of law. If they stop you and you do not give them any of their government-issued ID, then they don't usually do anything. Every state is different. Some states do not even ask for a signature on a ticket. If they compel you to sign a ticket, then this is the way you do it. No assured value, no liability. Make sure you put your signature down last. Okay. There's a guy that he's a truck driver. Okay, and he was doing this, and the Texas Motor Vehicle Division sent him a letter and told him that they weren't going to renew his truck driver's license because he was signing tickets like that, eh? And that's powerful, I'm telling you. Anyways.
What is it? I guess I don't understand. No assured value, no liability.
Right. That means you're turning your signature into an autograph. You're not agreeing to anything. I was doing that in a court case, and the judge, I was doing that in a court case, and the judge kept coming back and saying, your writings are unintelligible to me.
Can you also put it inside the box?
Well, you could, but again, this would be more powerful if I don't put it in a box. It's only, you know, they do it again because I don't go into commerce. Okay, I basically try and stay out of it. But again, if you're going to do it this way, you make sure and sign it last. Okay, leave room for your signature, because once you sign it, they'll jerk it out of your hands. Okay, so you put no assured value, no liability, by in front of your signature, duly authorized representative afterwards, and underneath, all rights reserved without prejudice. And that basically turns your signature into an autograph. Okay, that's you know, which is, there's no contract. It means nothing. And then. Do you want me to go back there? You still writing that down?
Yeah,
Just the last sentence. All rights reserved for that.
I have a picture of it. I can send it to you. If you want to send me is it on the disk email?
Huh?
Is this on the disk?
Yeah. Well, anybody, if you get my electronic package, then you'll get these PowerPoint presentations. Okay, for anybody that gets my electronic package, we'll get these PowerPoint presentations, and it'll come with free unlimited updates. Okay, in other words, I change these things all the time. You can send me an email 6 months from now or a year from now or whenever, and I'll send you the latest, greatest files. Okay. I'll email them. Yeah, it's.
Say my email address is on there. Just send me one.
Well, I have been sending you stuff.
Okay.
You get sent from PC settlements.
After inserting the signature, within 3 days, you got to serve it on them, their copy, okay, by registered mail, and with a cover letter telling them exactly what you did and why you did it. And then call up the court in a couple of weeks and see if they know anything about the ticket. Chances are they'll say, we don't have any record of this or something like that, or the case has been dismissed or something. Anyways, you're never the defendant, you're the duly authorized representative, which means that there's only one duly authorized representative. There could be a lot of authorized representatives.
If you don't sign a ticket, then they really don't have anything.
They got nothing, that's right.
I didn't sign the ticket before they give me a ticket for no driver's license.
Well, some states don't require you to sign it. I don't know. I don't know what they do in Texas. Some of them make you sign it. I don't know.
Most of the time they do, but in this particular case, they didn't.
So then you have do you got the ticket? I mean, what's the ticket say? If it says that you have to promise to appear and you haven't signed it, then you have to promise to appear. But you have no authority to, you know what I mean? Just go down the list and start telling them why they don't have any authority. Usually you have at least 6 weeks between when they stop you and any hearings. This is a perfect time to find out who the judge will be and who the prosecutor is and start serving them with your notices. Start building the case against them. If you can justify it, file criminal complaints against them and file criminal complaints into the case. I mean, you know, that's exactly, you know, what you do is start going on the attack. And if they drag me into their court, I say something like, there's a guy in Canada that does this, and it works every time. This is in Canada. I can't say for sure here how this would work, but in Canada he says, I'm the beneficiary for a trust with that name, and I appoint you as trustee, and I demand that you immediately settle this matter. Now are you going to perform your fiduciary duty, or do I have to sue you for breach of trust? And after that, after you make them the trustee and demand they settle the matter, they will get up, throw off their black robe, and leave the room. Under martial law, when they leave the field of battle, you've won. Parties, okay, this comes down to, if you go to number 4, remember I think I already talked to you guys about this, those persons who want understanding are idiots, lunatics, drunkards, and infants. So if they want me to understand something, then do you understand the charges against you? Well, there, Judge, it's interesting that you mentioned that. According to Bouvier's 1856 Law Dictionary, those persons who want understanding are idiots, lunatics, drunkards, and infants. So therefore, I can see you're not an infant. Are you drunk or just an idiot? That's probably just about word for word what I'd say. Yeah, and that's basically what I said there. Someone in BC asked the court, if you I'll answer whatever questions you want if you will answer one question for me. And the judge said yes. And then he said, is this a de facto court? And the judge said, get him out of here. And the reason is there's a statute in Canada that says that you can't be convicted in disobedience to de facto power, and that's all de facto. And so, you know, they threw him out. And I wonder if there's something similar to that here. I don't know. I haven't seen it. Anyways, well, here it is. No person shall be convicted of an offense in respect of an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. And that's in the criminal code. And so, therefore, you can't be convicted of an offense, right? Where they're de facto possession of the sovereign power. And that's what they are, exactly. And so when you bring up that point, is this a de facto court? Get him out of here. You know. Now, this is very important here. It's a rule at common law. The reason applies in equity and other civil law cases that if a party can plead a fact material to his defense and omits to do it at the proper time, he can never avail himself of it afterwards. And that's Penhallow versus Doan's Administrators. That's an old case. That's common law. And so, again, if you don't bring up the right issues at the proper time, in other words, if someone comes up to you on the street and says, you owe me $50, and you say, well, I paid you $35 yesterday, then by making that statement, you're admitting the contract, okay? Well, let's change that scenario a little bit. What happens if the IRS sends you a letter and says, you owe me $3,500, and you say, well, I filed last week? Well, you just saying you admitted the contract. Okay, and now it's over the terms of the contract, and they can do anything they want with that contract. So the best answer to give the IRS is there a contract here? I'm not aware of any contract. You see what I'm saying? You got to challenge the contract right off the bat. And if you do anything that admits that contract, then the contract's admitted, and you can never ever take it back. Okay? Now, that's not to say you cannot ever take it back. You can't ever take it back in that case. Okay? just in that case. And you could resolve that issue, get that issue resolved, and then in another case, say, is there a contract here? And there's nothing wrong with that. You see what I'm saying? So when they say you can never avail himself again afterwards, it's only in that particular case. A bill of exchange, and this is something that you could do with land as well, okay? I think you could. A bill of exchange was done with a vehicle that a bank was trying to steal. $5,000 worth of legal and equitable title in a vehicle worth approximately $15,000 was exchanged for labor to a third party. Okay, in other words, he had a vehicle that he was behind on his payments. The vehicle was worth about $15,000. He owed, he figured, about $5,000, and so he did a bill of exchange with him for $5,000 worth of equity for all the title to the vehicle. Okay? And so then he took that bill of exchange into the bank, and he said, I've done the $5,000 worth of labor. Now I want to know what your interest is in the vehicle. Okay, takes it to the bank, wants to know what the bank's interest is in the vehicle. The bank is owed, he figures, about $4,000, right? So, but he wants to go to the bank and find out what their interest is, and because he's prepared to pay off the bank's interest and get title to the vehicle, okay? And so he goes in, and all he says is, I want to know what your interest is in this vehicle, and here's the bill of exchange. And the bank looks at it, and then they tell him, come back in a half an hour. And he says, sure, no problem. Goes down the street, has a coffee, comes back in half an hour. Bank gives him title to the vehicle. And the reason is, they think, is that by doing a bill of exchange, something real for something real, that it took it out of the matrix. Okay? Because he said also that when he went to register the vehicle, it was completely different too. And so that's something that might be considered for real estate, to take it out of the matrix. Okay, a bill of exchange of some sort, and it doesn't necessarily need to be for gold or silver coin. It could be for labor, anything that's real, and something to think about. I mean, this is something. These are just ideas. This is something a friend of mine told me about, and this was their firsthand experience. They themselves did it, and that's how it worked. Again, that's all I can tell you. This is not something I've done. It's something a friend of mine did, but it's their firsthand experience. So that's something to consider. Okay. The bank released the vehicle. To my knowledge, this has not been done on real property. But if you did it on real property, you'd have to get it notarized, obviously. But beyond that, you could say something like that. What it potentially could say was, upon receipt of $5,000 worth of labor, Glenn Winningham, House of Fern, I hereby exchange all my legal and equitable title, because there's two kinds of title. There's legal title and equitable title, to the property described as blah blah blah, and that's it. It doesn't really have to be terribly complicated. And this would be a case where you're exchanging silver, but it's basically the same thing. Now, the next question is it's all in what you tell them. Okay, are you in Weatherford right now, or are we at Weatherford? If you're at Weatherford, you're at a place. Okay, if you're in Weatherford, you're in a corporation. Okay, and so that's really what it comes down to is understanding these words and using the proper terminologies. And so in Texas is a little bit more complicated, because I'd say I'm on the land of Texas, land known as Texas even. You know what I mean? And because even in Texas, you could say that you're in a corporation. It's little things like that.